This webinar will explore the issues that IP rights holders face when managing their intellectual property and engaging in transactions involving that intellectual property as a result of sanctions regimes that have been imposed by both the UK and the EU. Obviously, following the invasion of Ukraine by Russia in February of 2022, international sanctions law has undergone significant changes, and we continue to see rapid developments both in legislation and decisional practice. In particular, we've seen an increased focus on the investigation and enforcement of potential breaches of international sanctions law by both the UK and EU authorities. As such, now more than ever, it's important that companies familiarize themselves with applicable regimes and implement robust procedures to ensure that their activities are fully compliant with those regimes. So what does this all mean for dealings involving intellectual property rights? As I said, IP rights are included as part of the prohibition on dealings involving economic resources, meaning that all intellectual property rights that belong to designated persons must be frozen. What this means in practice is that you cannot transfer or alter any intellectual property rights which you already have access to that belong to a designated person. Any intellectual property office will also be prohibited from registering any such transactions. It also means that any intellectual property office of the UK or the EU cannot register any new intellectual property rights belonging to a designated person, even if the application was submitted before the person was designated. A similar prohibition is contained within UK sanctions law. As with the EU, the UK prohibits the provision of professional and business services to any person connected with Russia. That definition, connected with Russia, covers any person who's resident, located in Russia, an entity that's constituted under Russian law, or which is domiciled in Russia. The UK has also introduced its own prohibition on legal advisory services. However, unlike EU law, this prohibition does not apply to Russian persons, but rather to any non-UK person in relation to any activity which would be prohibited under UK sanctions law if it was carried out by a UK person or carried out within the UK. Practically, this would involve the provision of advice in non-contentious matters, which, as with EU law, includes the application or interpretation of law, participation in commercial transactions, negotiations and dealings with third parties, and the preparation, execution and verification of legal documents.